Hello, and thank you for joining us for a July edition of NARSOL in Action. Um, since we didn't have the conference, I was reached out to as far as doing a special NARSOL in Action, and it was brought up. Let's do a legal issue where we can go ahead and bring in some of our legal gurus to have a conversation about the different cases that they're working on. So tonight we have Stephen the paralegal, we have Mark Weinberg, and we have Larry King, who are going to talk about some of the work that they're doing. So, July, we have Christmas in July, and Hallmark and stuff like that. But NARSOL in Action, we have legal aspects in July. So, what we're going to do tonight is we're going to allow each person to speak about 15 minutes about the different legal work that they're doing. If you have any questions, go ahead and put it in on the question and answer spot on Crowdcast. What we will try to do is if it can be answered in that area, we will answer it then. Otherwise, we'll have about 15 minutes after each participant shares the work that they're doing. So first, what we're going to do is we're going to jump to Stephen, the paralegal, who has some stuff about the legal committee, Texas deferred adjudication, and West Virginia fee case. So Stephen, go ahead and it's all yours.
All right. Thanks, David. So it's good to be with everyone tonight. What I'd like to start with is the legal committee, because that's where all of our cases come from. And I'm just going to describe kind of the layout of the legal committee, how we work through cases, and how we decide which cases we will litigate. So currently we have 7 members. We have 3 attorneys, 4 lay people. And our mission is basically to bring impactful litigation. So we've, over the years, NARSOL has accumulated through generous donations enough funding to now have our own staff attorney. Larry joined us about 3 months ago, and he and I work together every week, sometimes every day, on analysis and presentation of various cases and getting ready for litigation. And you're going to hear shortly from at least the 2 attorneys that are with us tonight on the cases they're working on. So our committee is, I like a diverse committee. I chair the committee right now, and basically I like to have some pretty frank discussions on our cases. We try to avoid groupthink. We try to avoid confirmation bias. We want to know what the pitfalls in each case is. So I like to have some meaningful debate on every litigation case that we're presenting. We generally don't bring a case to the committee until we know that we have good case law behind it, that we've analyzed it pretty thoroughly, that we have a good percentage shot at winning the case, and that we think it'll be impact litigation. And I'll go over that with you in just a moment. But basically, we work through a case. In the end of the case, we vote on the case. And if it's voted to proceed, we proceed with litigation and filing litigation. And that's when the case actually gets turned over to the attorneys and they start working it through the court system. People often ask me, or I'm contacted frequently on how to present a case. So if you actually go to the NARSOL website, narsol.org, and I've got it on another screen here right now, but basically you bring it up and there's tabs across the top. Under the action tab, there's a population below that, and you click down on legal action project, and that goes to submit your case. And if you click on that link, it'll bring up a form that you actually submit online. And there's also a PDF on there that I created that shows you how and what information we need to look at a case for litigation. So maybe we can put that in the chat later or something on how to actually get there, but it's basically narsol.org. You go to the action tab, legal action project, and then submit your case. So that basically gives you the how to get a case to NARSOL. So from there, what do we actually do with the case? Well, for example, this year, we always have well over 100 litigation requests every year. This year, we're at 88 already, and we're just in July. We've had a significant uptick, I will say, since we hired our own staff attorney, which I anticipated. But the key factors that we look at, initially, I analyze the case and we look for constitutional issues. So in general, we want to present cases in federal court versus state court. And there's a number of reasons for that. If you think about it in general, we have appointed judges in federal courts and we have elected officials in state courts in general. So the federal courts are generally more willing to and open to our type of litigation. So that's one of the main reasons we like to use federal courts. In addition, if we win the case, we can get our attorneys paid for their work on the cases. And many of these cases, I think all of them end up in hundreds and hundreds of hours of legal work to get them through the court system and the appellate process. So that's in general what we look at as far as the court that we're going to address. We generally steer clear of some cases like criminal proceedings. Those are for defense attorneys and private attorneys. We were generally looking at registration issues, civil commitment issues post-incarceration. So occasionally we'll go in and look at prison litigation if, for example, inmates complain that they cannot get, for example, the NARSOL digest. We want to make sure that they have access to their legal mail. But in general, we work from the day that people leave incarceration forward with registry issues. That's what we're looking at. So when I look at a case, I give everyone a fair shake. And, we have a lot of different issues that we look at. I would say almost every one of them appears to be unfair. But what we're looking for is unconstitutional. And so I can emphasize that many of the cases are, troubling cases for sure. But when we look at them legally, we have to look at, is there a constitutional issue that we can address? And so we basically look at cases involving actions or inactions by government entities. The Constitution protects individuals from government infringements on their rights. So that's one thing we look at. I look at if we have a specific issue that's addressed. I often have to do a lot of case analysis in their area. First, I look at their state. Then I have to look at their federal circuit that they're in. Has the case been litigated previously? What's the court's been saying about what their issue is they're involved in? So those are some of the things that I have to look at before I would bring it to the attorney's attention. Is the issue clear? A lot of times we'll get litigation requests that are 10 and 12 pages long. And in general, if an issue is very complex, it's a lot more difficult for our attorneys to litigate. We like to look for issues that involve questions of law as opposed to disputed facts. But we refer basically clearly presented cases, and Larry's going to go over a case that fits that to a T here shortly, that is very clear. So we look for impact litigation as well. NARSOL basically prioritizes cases that have the potential to affect a broad number of registrants. We will look at individual cases, but in general, we want to bring litigation that is what we classify as impact. In other words, if we have a state statute that we can get stricken from the books and it affects every registrant in the state, that is a great case because it affects a lot of people. Mark does a lot of cases that involve I'll say zoning restrictions in certain cities and such. If it affects a lot of people, those are great cases that we like to look at. So, and then the final thing we look at is what resources we have to present a case. If we have, for example, we're going to bring a case and we know we need to have 3 expert witnesses. Well, we know that that's going to be about $5,000 or so for each expert witness. There's $15,000. Do we have to hire a state attorney? Sometimes we need to hire state attorneys along with our own attorney to present a case. Are they going to work on a contingency, or are we going to need to pay them? Those are some of the things that we have to look at. We do have an obligation to our membership to use our funds wisely, and we only want to present cases that have a good chance at winning, that we can get our funding back upon that win. So those are some of the things that we look at as far as choosing specific cases. So that in general is how the legal committee works. It's a pretty robust process. I'd say it's pretty thorough. You won't see us filing a case that we haven't researched high and low. So I do feel very confident about that, and I think my attorneys will agree here with me that we're not going to present something that's not too shabby. So just a few cases that I wanted to comment on, and then I'm going to have the attorneys actually talk about their cases they're litigating currently. The first case is filed through a state attorney. Occasionally we'll have, in this case, it's an issue with an interpretation of a state law. And so it'd be difficult to litigate in federal court, so we needed to hire a state attorney. So we need to go, in this case, we hired attorney Scott Smith out of Texas to litigate for us, if needed, an issue that involved deferred adjudication. These are people that are accused of a crime. They plead to the crime with a deferred adjudication, meaning that if you serve this 10 years of probation, we'll wipe out your conviction like you never had one. And that's what's occurred in Texas for years. Many states have this process. I think they all do. But in this particular case, people signed up for deferred adjudication, and they were told at the time that they didn't need to be on a registry. And then, of course, after the fact, some of these states pass laws and put them on a registry anyway, even though they successfully completed a deferred adjudication. So the case specifically is addressing registrants in Texas that did deferred adjudication before September 1st, 1999. And we've already had one person removed from the registry that was on the registry for 15 years too long. We have 2 more now that are both 25 and 27 years into their registration period, and they probably should have never been on the registry at all. So we're working through that process with Attorney Smith there in Texas right now. The DPS there, the Department of Public Safety, has been agreeable so far. And they're taking these people off the registry. We anticipate there'll be quite a few more registrants that get off the registry there. If we have to litigate, we will, but so far the state has been agreeable to work things out without litigation. So that's the Texas deferred adjudication case. You're going to see that we have a number of cases going on right now. I'm counting 7, maybe 8. And the next case was just approved last evening in our legal committee meeting. It's a case from West Virginia that deals with a registration fee. The majority of states do not have a fee to register. I think it's 24 or 23 states now that actually have a registry fee. West Virginia implemented a fee. Unfortunately, the statutory language for the state didn't include what the fee was going to be included for. That is, it doesn't address paying for the registry itself. The fees actually go for mental health and former employees and any other general state police issue. And none of the funds, at least as it's worded today, go towards maintenance of the registry. And all the other courts that have addressed this, there's 14 cases nationwide for registry fees. And we are going to try to get that law stricken as is. and get rid of the fee for an annual registration in West Virginia. So that's what that case will involve. It hasn't been filed yet, but we anticipate filing that in the months to come. So I think that's all I have. And if it's okay, Larry, if you're ready to go, it's your turn.
Okay, thank you. And yes, I'm pretty much good to go. Hi, everybody. I'm Larry King. I'm the new staff attorney for NARSOL. I think this has been covered a little bit. I'm going to try to sit back so that my head doesn't get cut off. But I believe we'll have time for questions at the end. But right now, I'm just kind of going to go through an outline that I have for our Oklahoma case. So we recently filed litigation in Oklahoma. We are challenging a requirement for registrants to have sex offender on their driver's license. The case is NARSOL v. Tempton. And again, I'll state the challenge more specifically is against a Oklahoma policy requiring certain people to carry a driver's license branded with the words sex offender. And this is in bold red letters. This isn't just a piece of paper. It's a government document. It's a government document with the power that impacts people's lives. Anyway, in Oklahoma, anyone required to register as a sex offender is forced to get the driver's license that has sex offender on it, and it's not ordered by a judge. It's doesn't depend on depend on their specific risk level, and it doesn't expire at a set time. Instead, it's a blanket rule that's enforced by the Oklahoma Department of Public Safety. And my view is that it turns the driver's license into a portable mark of shame. So what's the case about? To be clear, this case isn't about hiding someone's past or even about wiping the names off the registry. What we're asking in this specific case is to stop them from forcing government messaging through the registrants. It's about whether the government can make someone carry and show a label that they didn't choose and defines their entire and in ways defines a part of their identity by something in their distant past. Imagine documents that when I was initially looking at this case, I was imagining looking at different situations and just what if your ID required you to have criminal, welfare recipient, drug user, what's it called, thief. I was doing a thought experiment yesterday with white collar criminal for embezzlement and stuff. But there are different types of labels that could be used under this same type of framework that I don't think people would stand for. But in this instance, because a lot of people aren't willing to fight for people in this situation, it isn't viewed as bad, but we're arguing that it is. It's not justified, and it's permanent public judgment built on the most basic document that people rely on. So the people we represent, there are 3 individuals that were convicted of offenses years ago. They completed their sentences. They're not asking to be taken off the registry. In this case, they're not denying their past, but every time they hand over their license, they are forced to endure the shame, suspicion, and rejection, and giving that government message, even when they've gone years without incident and are doing everything right. So, in addition to those 3 plaintiffs, we also represent the two organizations, NARSOL, here, and Oklahoma Voices, which is a local group that helps people affected by registration laws and supports community reintegration and is an affiliate of NARSOL. Both organizations have seen firsthand how damaging these types of branding laws are, and they spent a great deal of time and energy resources helping people deal with the issues surrounding this. So I'm sure you guys understand how this can affect people and be impacting, but I'll still kind of go over that a little bit. When you carry a license like this, it has to be given to landlords in different situations, employers, store clerks, possibly, the pharmacy, even the bank for checks. This isn't just a label; it's signal broadcasting that you have been marked, and they want to keep this mark. What the research tells us, this isn't just a theory. There's extensive research showing that policies like this don't increase safety, but they do increase the harm. Human Rights Watch has reported that public labeling and ID branding significantly impairs a person's ability to find housing and employment. And I have other statistics, which I don't know yet if we're going to use in the actual filing, but maybe. But we're doing a lot of research on it, and I can discuss those. I don't want to go too much more into those sources or my analysis of different cases that help us, but I'll move on to why this violates basic rights. The government in this country, the government can't force you to carry its message. That's part of our First Amendment jurisprudence, and it protects not just your right to speak, but also your right not to speak. The government can't. The government can run a registry, and the lines of how and all of that are things that we challenge and try to litigate. But having a registry, that is something that under the law right now is permissible, but it can't, and it can require reporting, but it can't force people to carry a label that acts as a constant billboard for public condemnation, because that's the message that they want to send. So again, we're not asking them to change, in this case, we're not asking them to change the registry. We're not asking for special treatment. We are trying to protect their First Amendment rights and protect them. So the basic ask is let people carry a driver's license that doesn't publicly brand them. And the subcategories of that would be to have the state stop issuing these branded IDs, hopefully a declaration that this forced labeling is unconstitutional through the court, and a process for people to get standard IDs without the mark. And there are more details about the cost that it has with them having to pay for this license with the labeling and things like that. But again, that goes more into the weeds. Why this case matters beyond Oklahoma. Oklahoma's law is among the harshest in the country. And let me add to that. I really like the way that sounds. It's the harshest, but the reason that it's the harshest is because several other jurisdictions have already come to the conclusion that Oklahoma really should have by now, that it's unconstitutional and that they shouldn't be doing this to people. And those states that, whether it was because they want to protect all of their citizens' rights, and they're doing this out of their goodwill, or the cynical view that they simply don't want to be overturned on an issue, have moved to a, as of right now, permissible different type of branding by putting a code on the ID. While I think this is still potentially problematic and that should be changed, it's still much better than having bold red letters saying sex offender on one's ID card. The code to me is, like I said, it's better, but because other jurisdictions have found it unconstitutional and even more have just used a code, Oklahoma does have that title of being one of the harshest in the country. I described the image, and I'm trying to see what more about this. I mean, we're really trying to make it clear that trying to help people. Another thing I think this case will do is make it clear that there are boundaries for what you can do in these types of situations, and violating one's First Amendment rights for something that has, well, violating somebody's First Amendment rights, I think is going to be our strongest claim, because it requires an analysis that is much harder to win than other types of challenges. And I am very optimistic about this challenge, and it has made me more excited, even more excited about doing this type of work and the litigation. I don't know if I've gone too long or if I've said everything that I need to, but that's what I have.
Okay, thank you, Larry. We definitely appreciate that. And so what we'll do now is we'll go ahead to Mark and the 4 cases that he's working on.
Okay, thank you, David. Thank you, Larry. Thank you, Stephen. My name's Mark Weinberg. I'm a lawyer in Chicago, and for the last 12 years, my co-counsel, Adele Nicholas, and I have devoted our practice to challenging laws that are imposed upon people that have been convicted of sex offenses. We got into this business totally arbitrarily. We made contact with Illinois Voices for Reform, which is a NARSOL affiliate in Illinois, and they were looking for a lawyer. And we knew nothing about the restrictions that were imposed upon people that have been convicted of sex offenses. But over the course of 6 months of talking to the 4 guys who were running at the time, Illinois Voices, we learned all about these horrible, dare I say, evil restrictions that are imposed. And for the last 12 years, Adele and I have been bringing challenges to these various restrictions. And I'd like to tell you about 4 that we're working on right now. A lot of words, so I'm just gonna, give you the skeletal summary of these 4 lawsuits. The first one is a lawsuit in that we're challenging about a policy in Wisconsin. The policy is GPS for life for people that have been convicted of 2 or more counts of a sex offense. Yep, you heard it. GPS for life. We're saying that this is a violation of the 4th Amendment, the 4th Amendment being the amendment that prohibits unreasonable search and seizures. And we're saying this is both an unreasonable search because the GPS monitors where you go 24/7 every day of your life for the remainder of it. And it violates not only the search, but it's a seizure because you're forced to wear an ankle monitor, GPS ankle monitor, that's unremovable. We're basically claiming that the scheme of GPS for life is unreasonable for 3 reasons. 1, there's no individualized determination of dangerousness. 2, it lasts for life. And all the scientific evidence suggests that after 10 years of being offense-free, a person no longer is any more dangerous than the average person in the community. And 3, we're challenging the indiscriminate sharing of data that goes along with this program, meaning anybody can find out the GPS data of a person who is subject to this law, meaning an ex-girlfriend can find out where somebody was, some ex-boyfriend was during any time period that they wanted to know. This in itself endangers people and makes the scheme unreasonable. I should mention that this lawsuit's been going on for 8 years now, and we are at the 7th Circuit Court of Appeals, and our reply brief is due in 2 weeks. And NARSOL generously donated $30,000 to this case to support our 2 expert witnesses that are testifying on our behalf. But we did lose in the lower court, and we are now on appeal. I'm happy to answer questions about that if there's more. But the second case that we're doing that I want to share with you is a case about parole restrictions in Illinois. We're challenging a particular parole restriction that is imposed upon people that have been convicted of sex offenses, which prohibits anyone on parole for a sex offense from using erectile dysfunction medication. Of course, this inhibits people's ability to have normal sexual relations with their partners while they're on parole. And we think it violates the substantive due process of the right to intimacy. But really, the case is not about ED medication. It's really about a policy in the Seventh Circuit Court of Appeals, which is where Illinois is located. The Seventh Circuit controls Illinois, Wisconsin, and Indiana. And in those states, the Seventh Circuit rule prohibits people from challenging parole restrictions via the civil rights laws. Instead, it requires you to challenge these laws via a habeas corpus petition. I don't want to get too much into the weeds, but because it requires challenging via a habeas petition and not a Section 1983 petition, it makes these challenges basically impossible. And that's because if you have to challenge them through 1983, there's no attorney's fees. You can't do a class action. You have to go through all the state court, all the levels of the state court first before you can get to federal court determination. And this makes it very hard to challenge parole restrictions in the Seventh Circuit. I only want to mention that there's a conflict in the circuits about the ability to challenge parole restrictions via Section 1983 as opposed to habeas. And that is the Ninth Circuit, the California Federal Appeals Court allows challenges via Section 1983, parole challenges. So whatever happens in the Seventh Circuit in that case, and this case too is in the Seventh Circuit, there's a split in the circuits, and we hope to get the Supreme Court to resolve the conflict. The third case that I'd like to talk about right now is a case involving residency restrictions, and in particular, a challenge against the city of Rockford, Illinois, which about a year and a half ago passed a zoning ordinance which prohibits any person on parole or any type of criminal supervision from living with another person on parole or criminal supervision. And this is a horrible burden on access to this, horribly restricts access to housing. And that's because it's a lot easier to live with somebody on parole who than to find a apartment or building without of people who are willing to rent to you when you're on parole. And so parolees being allowed to live together is very important for them to find housing. There's a lot to be said against the city of Rockford's ordinance, including the fact that if it's allowed, if it's upheld, and we're a year and a half into the litigation right now, there's been no court decision yet. But if it's allowed, we have very little doubt that other municipalities would pass similar or the same law, and which would, again, severely restrict housing in available housing for this population. And I should mention that the law applies to anybody on parole, but it's clear based on Rockford's representation that it's primarily directed at people that have been convicted of sex offenses. And the fourth case that I'd like to share with you is a case that we have in Illinois against the Illinois State Police, which is the agency that controls the Illinois Sex Offender Registry. And basically, the Illinois State Police has made it impossible to correct errors on the registry. And we want them to implement a program that allows people to inform the state agency, the Illinois State Police, when errors have been made. I'm going to stop there. that's a lot of words, but if anybody has questions, I'm happy to answer any and all. Thank you.
Okay, thank you, Stephen, Mark, and Larry, for sharing the different work that you guys are doing. We appreciate it. We already know that there's a lot of work to be done. You guys are doing incredible work. One thing that we're going to do at the end of this program is provide those who are listening emails potentially where they can reach out to you if they have any other questions that you could actually answer. So let's go to a couple of these questions that we have on here. So one of the first ones from Amanda. They say, can low risk offenders who are put on lifetime registration fight that?
I'm sorry, fight being put on the registry?
Lifetime registration.
In Illinois, what state are we talking about?
They didn't put. Amanda, what state are you talking about?
But basically, the answer is no. There's no individualized determination of dangerousness for sex offender registries, and so it's a categorical imposition. If you're, there's different lengths of time, obviously, that people are put on the registry. But if you're put on it for a certain length of time, it doesn't matter if you're low risk or high risk.
Okay, and they were from Texas, and that was where the question was from. Okay, the next question. Is there any movement on the international Megan's Law that also requires forced government speech on passports, like driver's licenses being discussed, makes international travel more difficult and dangerous? This is from Tim.
So I can address that one. We get a complaint on that at least once every 2 months. I'm well aware of the provisions. Of course, there's a previous case that was brought, I believe, in 2016 before the label was actually put on the passport. I do want to bring a case to the NARSOL Legal Committee for that specific provision. However, there's a reason that I brought to Larry and the committee the Oklahoma case first. If we can first get rid of the compelled speech in states and get rid of all of them, we have a case coming up in Mississippi on this as well. That gives us some more precedent for getting labels off of government IDs. So far, we've been very successful in every case brought in the country on this. Louisiana, Florida, Alabama, they've all issued court orders that said it's compelled speech when they present people's convictions of sex offender or criminal sex offender on government ID. The passport is a little bit different entity, and some courts have stated that the passport is not personal to you as an identification card as a driver's license. And I don't want to get into the weeds on this because the government says that it's only to inform other countries about your previous convictions. So, but I am aware of the case. We've talked about it in the legal committee before. We don't feel it's ready for litigation yet, but following, I am sure at some time we will file a challenge to the passport identifier. It's a good question, though.
Okay. There were a couple different questions around things like that. So I think what you answered is definitely cut some. Is it possible to get all states to interpret language the same? This person's from Missouri Lifetime Supervision. They say that is GPS monitoring. Michigan, where I moved to, sees that term as lifetime parole. This seems to be vastly different. So, is there anything that can be done as far as getting language used in the same place? And this was from Ronnie.
Well,
Not everybody wants now. Come on.
listen, I obviously get litigation requests from all across the country. I have to look at nearly every state registry. They're all different. States have some sovereignty in creating their own laws. And I don't see that happening. Everybody agreeing on all the same registry laws in every state. I mean, many states don't have residency restrictions. Many states don't have fees. If ever, I just can't see all the states giving up their independence on creating their own registry laws. That's my opinion. I don't know. Larry, do you have any thoughts on that?
I mean, my first reaction was just no. I don't think there's a way, or that all states would ultimately agree to a certain language. I mean, I do think that, if certain legislation is being proposed or things to be changed, there could be coordination in terms of like there are, I'm trying to remember what it's called, but like sample form or things that are produced and distributed to multiple states for proposed legislation. But ultimately, I think the states like to be able, or they want to be able to have their own and distinct laws, some even trying to be stricter than others. And as I learn different jurisdictions, I mean, in New York, I was very surprised that there wasn't a hearing to decide what level somebody would be, because that's what I was very used to in New York, and seeing that other jurisdictions didn't. Well, not that no other jurisdiction, that all jurisdictions had it, but just seeing that most did not, surprised me. So, in conclusion, no, I don't think it would ultimately be, but I mean, when if people are lobbying and coordinate to try to get proposed legislation changes, maybe things could get closer to some type of the same in other jurisdictions. Does that make sense, Mark? Stephen?
Oh, it makes sense totally. I have nothing to add to this question.
Okay. Thank y'all. Next question is from Randall. He's 68 and in Florida, and he has serious health issues, and his concern is about nursing home care. He has family that could take him in, but he doesn't want to have their address on the registry because of his grandkids. So is there any type of insight that you can give him as far as nursing home care in Florida?
I guess I want to say this is a huge problem throughout the country. It's a problem in a couple of different ways. One is that private nursing homes are reluctant to take in somebody who has a conviction. And that's because of laws in the state that require a nursing home that takes in somebody like that to increase security, which makes it prohibitively expensive. That's one component, the private care. Then their public care is that, the Medicaid, I think, prohibits people from going into subsidized nursing care who have sex offense convictions. And so that leaves people really out in the cold. The only way to solve this problem is to get legislative change. We're trying that in Illinois. I don't know what's going on in Florida about that.
I would just add, David, that the person that asked the question may want to contact the Florida Action Committee, which is our state affiliate in Florida. They probably have better insight into the nursing home situation there.
Okay.
And they can contact NARSOL, and we can get them in contact with them.
Okay. Next question. My son is on the registry and has been asked to do artwork for a children's book. His PO says he probably shouldn't, but doesn't the First Amendment protect him? What would you advise?
Well, okay, so this is something that I deal with every day, which is parole officers that are acting beyond the scope of their powers, and how to, this this is a little different. As I read the question, it suggests that the parole officer is just saying it's a bad idea, but he's not prohibiting it. We have parole officers who prohibit people's speech all the time. It's a problem. But my advice is your son should definitely pursue his passions. And if the parole officer interferes with those passions in a way that violates his constitutional right, we should sue the parole officer.
And I would just add, I mean, he already took the steps to alert the parole officer, and the parole officer already said that, I mean, did not prohibit it. So I think that puts you on more firm footing. But yeah, I agree with Mark.
Okay. Are there any cases challenging the constitutionality of residency restrictions? It's hard to see how local restrictions where entire municipalities effectively ban PF4s are constitutional.
There are a lot.
Anybody else? I mean, we've brought 6 or 7 residency restriction lawsuits, all in Wisconsin. And we've been successful to varying degrees on all of them. So the answer to the question is yes, there are successful challenges. And the unfortunate reality, though, is that these residency restrictions are all over, and there should be a lot more challenges. And I anticipate that NARSOL will bring a lot more challenges in the future.
Okay, this specifically is to you, Mark. If you lose appeal for lifetime GPS, what is the next step to try to get a victory?
There's only one more step, and that's the United States Supreme Court. So we will definitely, I will say this, whoever loses at the Seventh Circuit is going to appeal to the Supreme Court. But that's down the road. There's not going to be a decision for at least, I'd say, another year. As I said, our brief is due in a couple weeks. Oral argument will then occur about 6 weeks after that. A typical decision at the Seventh Circuit takes about 6 months to decide, but I suspect something as big and as significant as this is going to take a little longer. So again, about a year.
Okay, thank you. What about the Illinois pop-up daycare residency restrictions?
Yeah, that's in Illinois. The pop-up daycare. Well, I've heard of pop-up parks, but I guess pop-up daycares are a thing too. It's a horrible problem. Adele and I brought a case that we lost about 4 years ago, in which we challenged the constitutionality of the residency restrictions in Illinois because they don't have a grandfather clause, which then means that if there's a pop-up daycare or a pop-up park, people have to move from where they have homes. And so nobody in Illinois can ever feel safe where they live. And this is a problem, and we're trying to work with the legislator to include a grandfather clause in the residency restrictions, but so far we haven't had luck with that. But I hope within the next few years we will.
Okay. Many cases get resolved on summary judgment, and then the lack of factual record hurts us on appeal. Is this factored into the cases taken in trial strategy? Because I've seen this issue torpedo so many cases that has a shot with better evidence testimony. And this is from AS.
Well, go ahead. I mean, I would say, yeah, it's definitely making the record is key for an effective appeal. So we definitely take that into account in every case we bring, trying to make sure that our record is strong enough so that we can appeal it effectively.
Um, I agree with what Mark said, and I would say that yes, that is an issue, and we do discuss things. I feel like I've definitely heard that question before, and we addressed it similarly. But I just want to also say that in certain instances, the being successful on the summary judgment or us seeking that um, us seeking that as what we're going for, it can be beneficial. So just making sure that you're saying that sometimes it's an issue, wherein in other instances it could be a good thing to have the summary judgment win.
Okay.
I have nothing to add with the exception of when I review cases, the question presented is a good question because repeatedly I see cases that falter, as Mark stated, on appeal because of a lack of record in the underlying court. So it is a very good, valid point. And when we strategize these cases behind the scenes, Mark or I or Larry now, we discuss all the possibilities on how the state is going to come at us. I mean, that the part of having a good offense is knowing what their defense is going to be. So we work through all the possibilities and make sure, at least in the cases we're presenting ourselves, we're going to make sure that we have a good record for appeal. So,
Okay. Will the Adam Walsh Act ever be challenged? This person went from 10 years to lifetime registration because of it. And that question's from Noel Brown.
well, it's kind of I think you'd have to get a little bit more specific here on this case. The Adam Walsh Act per se, the entire scheme or parts of it, or the duration of registry, I kind of have to have a little more information.
That's all they put in it. So
Okay.
Yeah, I was assuming it meant a successful challenge against the entire registry.
The federal SORNA Act, yeah.
Yeah. Or in case of the yeah. I mean, in general, there are lots of challenges, but to the specific, I'll just wait.
well, we can always have them reach out to you too and ask specifics, and
Yeah.
we might not, we're probably not going to be able to get to all the questions because there's still more questions coming in. So as I said, at the end of this, in a couple of minutes, we're going to have each lawyer give a way that you can reach out to them for further questions and comments, and then any insight that they can give you as far as reaching out to people locally, especially those that are dealing with housing issues that are elders. Another thing to think about too is one of our uh, speakers that we're going to have at the conference, Dr. Stephanie Jerstad. She was on NARSOL in action a couple months ago, and she's does a lot of research around elders and the housing and the placement of individuals in nursing homes, stuff like that. So she would definitely be a great resource too for people to reach out to. She's at Millersville University in Pennsylvania. Um, so Susan H put that over 200 men now in Parchment Prison were deceived and entrapped in Mississippi. Have you or is anybody doing anything about that, or have you heard anything about it?
I don't know anything about that. I'm sorry. But
Like,
David, how are people going to reach out to us? Should we post our emails somewhere in the chat or something?
Um, go ahead and just say your emails and I'll go ahead and type it up. if you want, put it in our chat and then I'll share it with them.
Okay.
So I have to intervene here real quickly. As far as NARSOL's staff attorney, the committee's generally coming through me before they go directly to Larry. I know he's going to get bombarded if we give out all his information. That doesn't mean, I mean, I will review it and certainly forward it to him, but we really want to keep kind of a, I'll say a chain of command from the military days.
Okay.
Mark, you're welcome to do whatever you want to. You're a private attorney, so.
What is your email, Stephen? How can they reach out to you?
It's pretty simple. It's paralegal@narsol.org. And they're welcome to reach out to me for any questions they have, specifically for legal questions, obviously. And I do get back with everybody, usually within a few days. And if you have specific questions for Larry or, litigation requests, you can do that on the website. Or if you have, many people have questions like, would this be a good case? And they don't want to fill out a litigation request. You're more welcome to send that to me. And sometimes I'll reach out by telephone to clarify what their issue may be. So.
Okay,
and just, can I add one more thing?
Go ahead.
And Stephen regularly talks to me about different submissions or different submissions, as well as just different people that have contacted him, not necessarily in the formal process, but talking about a legal issue. So we do discuss those things quite regularly, and I get back to people. So feel free to ask him or just submit the question, follow the process that he entered in the beginning. But I am regularly available to deal with those issues. So just go to him first.
So we are going to do one more question because we're coming up on the top of the hour. So this is from Gus, and I think both Stephen and Larry and Mark can all respond to this. So how does NARSOL determine when to join with a local affiliate to do joint work on the case?
Well, for example, we just joined with Oklahoma Voices. They brought the actual litigation request themselves. So we have an obligation to them to bring litigation with them as a plaintiff. We'll probably do the same thing in West Virginia. The West Virginia ROSOL brought the litigation request. So we will likely join them in the litigation. So we like to have our state affiliates join our litigation. It helps them get the word out in their state. It helps with the whole process. So we try to join them as much as we can. I don't know, Larry, do you have any other input on that, or Mark?
I don't have any input on the process for affiliates. I'm getting more familiar with that myself.
I don't have anything to add either. I mean, we have Illinois Voices for Reform. That's our affiliate here. And we have brought cases with them as the named plaintiff. Yeah, I think that's a very powerful thing for the organizations to be the litigants.
Well, I want to thank you, Stephen, Larry, and Mark, for being on this special edition of NARSOL in Action tonight. Thank you for everybody that joined us. We had a whole bunch of questions, and there's still probably going to be questions till like 1 a.m. coming in, because this is something that, we could spend hours talking about. But we could definitely have a discussion about doing another special legal edition in the next couple months to see where we are on the cases that you're working on, and also new cases. So definitely thank you all for the amazing, incredible work that you're doing. Everybody that joined us, I hope that you guys have a wonderful night, and we look forward to seeing you guys at the next regularly scheduled NARSOL in Action in September. So y'all take care and see you then.